we'll move on to our next speaker with his second contribution, Jonathan Brown. And I found his paper very fascinating and difficult and detailed and heavy in terms of the law, but he's sort of going to almost finish the legal discussion on this quite a positive note in finding ways in Scots law in how we can vindicate some of these interests using the concept of eadem persona cum defuncto, and the previous discussion he had of his axiom in iuriarum. So it's really interesting. And Jonathan, please just recap or add anything else you would like to add to that. Thank you.
Thank you, Dina, and very, very interesting talks from both Michael and Lee. They're very, very interesting indeed. I do apologise. Of course, Adina asked me, as I think she asked a lot of folk, to send on a short paper, and I've sent about 10,000 to 15,000 words, depending on whether you're using footnotes or not. And I believe Heather Conway is on this call. She was one of my 2 external examiners for my PhD. Hi, Heather. And I think she knows as well as anyone that if you ask me what time it is, you'll get a precis of Stephen Hawking's book, A Brief History of Time, rather than a straight answer. So yeah, there is a lot of detail in the paper that I submitted there, but really that's because a lot of this is still rather new to me, and I'm still working through a lot of material in respect of this. So the paper that's there is very much a work in progress, a statement of here is where my thinking lies at the moment. It's one that can change quite rapidly, I think. But essentially, yes, in terms of the first contribution that I made to session 1, my overarching point there was that lawyers do feel most comfortable with what I think Michael was talking about. When you're dealing with property, things are a bit more black and white, easier to comprehend because there is this framework in place. Certainly, when you get into the non-patrimonial or dignitary interests, even in civil law jurisdictions, the lines become blurred for lawyers quite quickly, because even if you are dealing with a affront to non-patrimonial interest, money is the universal solvent, to use the quote from Walton Eves in Old Against Sharp. You're asking for money to repair a form of wrongdoing, whatever that form of wrongdoing may be. And so even when you're dealing with non-patrimonial interests, there is this patrimonial consequence attached to it. And that makes the position quite complicated, I think. So my first contribution was really about saying that we need to develop a robust framework of personality rights, personality interests, if we are, and apply that in respect of the living, if we are to do the same for the dead. And in respect of that, I think that the Roman Actio in Iuriarum provides a good blueprint and good roadmap for the development of that. And there are 2 pandects in particular to fragments taken from Justinian's digest, which I think are of interest here. One being what I alluded to earlier, and that's Pandect 47.10.1.6, which essentially says that if any contumely, if any injury be directed towards a dead body, then essentially there are 2 several actions which can arise. Both of them are actiones in iuriarum, but 2 separate actions arise there conceptually. One which pertains to the affront caused to the deceased themselves, but another separate harm which is effected against the nearest relatives of the deceased. Now, in Roman law, this was kind of unified under the concept of an heir, but certainly in Scots law by the 17th, 18th century, there is a clearer divide. The heir has an action, and that heir's action stems from the connection with the deceased themselves, in the most literal sense, coming from the eadem persona cum defuncto rule, but separately, the nearest relatives, whether they be the heir or not, have an action for the affront that is caused to them directly as a result of the interference that has gone on. And I'm saying that point really as a prelude to indicate that conceptually we can and should separate out two types of harm affected where the dead are concerned. The harm done directly to the deceased person and the harm done to the relatives of the deceased person. Now, of course, one major issue, which we've discussed quite a lot here, is, well, can you harm a deceased person? And my answer to that is an unequivocal yes, because where the law is concerned, the word person has and always has had a technical meaning. It doesn't merely mean a human being, because some human beings can be denied legal personality. Those human beings are slaves. Some entities can be imbued with legal personality, even though they don't have any kind of tangible existence. Corporations, partnerships, conceivably in Scots law, even trusts fit within this category. That background is important because the eadem persona cum defuncto rule, although it's often cited in the courts, and although it literally means that the executor or the heir, depending on what time frame you're talking about, but we'll go with executor for now. The executor steps into the shoes of and becomes the same person as the deceased. This is, in effect, a survival of the institutional personality of the dead person. And although we quote this statement, oh yes, the executor is the eadem persona cum defuncto, although some of the consequences of this are borne out in allowing the executor to stand in the place of the deceased where patrimonial loss is concerned. If anything harms the estate of the deceased person, then the executor has a legal claim in that regard. If the deceased person in life had harmed anyone else, then the executor is the person who you chase after to get reparation if they die before you're able to do that. From the 19th century, certainly, the courts turned their face against recognizing the logical consequences of it and applying it to non-patrimonial harm affected either to the deceased person when they were still alive or indeed after death. So that's where this reluctance is coming in there, really. And what my argument in the paper was, and the position I'm still cleaving to at the moment, although, as I say, I'm very much in line to have my mind changed about this, depending on where the discussion goes, is that where this problem is concerned, I do think, as I said in the beginning, that, and as Lee said, I'm heartened to hear an English barrister talk about first principles. That's just absolutely great from my perspective here. But very much of the view that we should be starting this conversation with a consideration of the principles that are there and see if those principles can be developed or adapted to solve the issues that we're identifying here. And I do think that a lot of the things that have been alluded to in the course of this discussion could be addressed if the logical consequences of the eadem persona cum defuncto rule were to be borne out. Because essentially there, what it would mean is you have a temporal representative who is, to all intents and purposes in the eyes of the law, the same person as the deceased, meaning that they have the ability to vindicate any interests of the deceased, and indeed can be imbued with duties in the same way that the executor is not the heir. They do not get the inheritance for their own benefit. They get the inheritance with the purposes of distributing it amongst the beneficiaries. Likewise, it seems conceptually we could quite readily bind the executor to fulfill the wishes of the deceased. Now, that, of course, doesn't answer the question that Burkhardt alluded to. Well, what happens if we're dealing with a literary figure who has decided, no, he wants all the manuscripts burned for whatever reason. But I don't think that that is an insurmountable objection, because I do think, and I think it was perhaps Lillian or someone else earlier who talked about the public, it was Lillian, the public policy dimension of this. There are times at which the courts are unwilling or reluctant to do something because of public policy. Turning that on its head, you could concoct perhaps a public interest, public policy justification for disregarding the wishes of a deceased person if they are of particular import. But I think, if anything, the rule that we should be starting from is that the deceased should have a representative, and we do have a ready-made representative in the form of the executor who can deal with issues of this kind and fully represent the deceased in any aspect of this.
Okay, great. Thanks, Jonathan. That's great news, and I do agree with everything you've said, particularly with regards to developing principles first, and then remedies. But I know that English lawyers will wholeheartedly disagree.